Welcome back to The ReidOut. The game is on, and the ball is in special counsel Jack Smith's court in terms of Trump's ongoing effort to delay his federal election interference case over a bogus claim of presidential immunity. This morning, the Supreme Court responded to Trump's request to put on hold the last week. The D.C. Circuit Court of Appeals, their ruling that rejected that immunity claim, he wants to stop it. He wants to stop everything in order to hear more about why his claim was rejected. Chief Justice John Roberts is giving the special counsel 1 week to respond to Trump's request, even though it's unlikely that Smith's team is actually going to take that long. But the bigger question here, the one that everybody's wondering, is what exactly is the Supreme Court going to do next? Joining me now to discuss all of this is former federal prosecutor, my friend, and super lawyer, Glenn Kirshner, MSNBC legal analyst and host of the Justice Matters podcast. Sir, I have not been able to take off my glasses the entire night. We've had a big one in terms of news, but now I get to talk to a lawyer and finally do that. First and foremost, what are the chances that Jack Smith responds and the Supreme Court says, we're not going to deal with this? Because I'm not convinced that they're actually going to take the case and review it at all, but you may think different.
I agree with you, Charles. I think there's going to be some really powerful foreshadowing by what the Supreme Court does on the stay issue. Think about it. I agree with you. Jack Smith may not take the full 7 days, even though 7 days is a pretty short fuse deadline. We may see something in 2 or 3 days because Jack Smith understands, as do we all, that we're burning democracy daylight. There's a real urgency to get this case to trial. So if the Supreme Court refuses to stay the case, they return it to Judge Chutkan, telling her, put it back on the trial track. I think that will be powerful foreshadowing that they will either not take it up at all and just let the trial proceed, or if they do take it up, maybe it's because they want to be the big dogs on the block. And even though they agree with the resolution by the D.C. Circuit Court of Appeals, they want to write the words for posterity and put their own spin on why a president should not be permitted to commit crimes against the American people while in office and, remain completely unaccountable for those crimes. So I think it's not the whole ball game, Charles, the stay, but boy, it's a good 7 or 8 innings of the ball game.
I hadn't considered the idea that they might take it just to put the nail in the coffin and definitively, like you said, for posterity, make it absolutely and abundantly clear that this absolute immunity thing that he's argued it's not a thing. And that's an interesting point. My money is on the fact that they're not going to take the case at all. But let's shift gears. We're going to go down to Fulton County in Georgia. There's been a lot of conversation as we have watched this controversy develop about the Fulton County DA's office, particularly Fulton County DA Fani Willis, and an alleged inappropriate relationship that she had with one of her special assistants. We are looking at a hearing on Thursday where the judge has already stated that, or leaned or suggested that there may be sufficient evidence to support a disqualification of the DA here. If you are, who has more cause to be concerned? Is it Trump's team as they may smell an out, or Fani Willis's team as they may smell trouble?
Yeah, there's a little bit for everybody to dislike about the way this is playing out. But here's the thing, Charles. Let's get an evidentiary hearing rather than having this issue bouncing around in the court of public opinion, where there are no rules of procedure, there are no rules of evidence. And what Judge McAfee said is, listen, there's a possibility that this relationship and any financial entanglements might result in a disqualification, but we won't know anything until we have an evidentiary hearing. What I've seen on the papers that have been filed thus far, it's hard to see how any of this inures to the detriment of any of the defendants. If anything, it looks like it might be a matter for bar counsel to take up if there was some ethical misstep. But listen, the best way to resolve this is by, putting it in the full light of day in an evidentiary hearing controlled by Judge McAfee, who seems to be up to the task. He's been doing a pretty good job presiding over these cases, and then we're going to have to let the chips fall.
Glenn, last question. Donald Trump, between now and February 24th, which is the Republican primary in South Carolina, is going to be all over the map with court appearances and everything else. What's the one date that you're watching for? He's got appearances in New York. There's the Section 4 stuff that's going on in Florida, and then obviously the other things that are going across the map. What are you watching for in particular?
Charles, I'm looking for 2 days from right now, Thursday, because that's when he's going to be back in court in New York in his falsifying business records case, which is really an election interference case, interfering with the 2016 election. And I think his attorneys are going to push hard to have Judge Merchan vacate or postpone his March 25th trial. Because if the judge holds that trial date, he's going to be in trial starting March 25th, and he's going to be in trial every day for weeks and weeks and weeks. That's going to really cramp his campaigning style.
Grand and glorious as always. Glenn Kirschner hits it right on the money. Thank you so much for being with us. And that's going to do it for tonight's ReidOut. I'm Charles Coleman Jr. Joy will be back here tomorrow night.